to the podium.
All right, good morning.
Good morning, Your Honor. We're on number 7. This is Wells Fargo versus Mercedes Pupo.
Yes,
Yeah.
I've read it. I'm going to grant it to May 19th at
May
10 a.m. for trial. Good argument.
Number 15.
Do me a favor, we need to make sure we keep that. Arthur?
Yes, sir.
We need a copy of this for us so that we
Okay.
take it off and put it on one calendar and put it on another, okay?
Yes, sir. We'll take it.
Number 15, good morning. I have an agreed order on the motion to strike.
All right. Oh, an agreed order.
Yes.
Okay. Let's see. Okay.
Thank you.
Okay.
All right.
Number 6, Roy.
Are you?
Is this set for trial or not?
I can pull the docket, Your Honor, and find out either way. It's Wendy's file. She didn't tell me, so I can
Okay.
I can take a look.
All right. Yeah. I'm gonna need to know that. I need to know whether it's going to affect the trial date or not.
Yep.
That's my
Okay.
question. Okay. Okay. All right. I'll come back to it in just
Okay.
a second. All right. Stick around. Thanks.
Roy, let's just go ahead and do yours, please. Okay, please. Number 1.
Can, when you get a chance, Benita, number 6, just check and see if it's set for trial or summary judgment. Okay. All right. What number is this now? Number 1. All right. Has there been anything filed or not?
Yes, Judge, we filed two things, a motion to transfer and a verified answer from the defenses.
Ooh, motion to transfer. Granted. Except I don't have the power to do that. So
Go see Bailey.
what's that?
Go see Judge Bailey.
Okay, good. All right. All right. So it's denied. Is the bottom line.
Okay, we'll prepare the order, Your Honor.
Okay. All right. What else?
Number 2.
Okay. Tell me the name of the defendant on number 2.
Yes, Marielle Martin.
Marielle Martin.
Okay.
Anybody on that property? Okay. Granted.
Thank you, Your Honor. Number 3.
All right. Any opposition?
I have no opposition to the withdrawal, but we are
Okay.
also set on plaintiff's motion as sub-party plaintiff.
And the motion for leave to amend.
Yes, to change the name of
Right.
one part. Okay, so Your Honor's
All right,
reviewed
so,
it.
yeah, on the motion to substitute party plaintiff, it's granted.
Okay,
On the motion for leave to amend the complaint, that's also granted.
thank you, Your Honor. And the court will grant the defendant's motion to withdraw as well, or not? No
I
ruling?
think I had already entered an order on that, but I may be wrong. But I thought I had done that very recently, and it just,
Okay,
Yeah.
I can look at the docket and see if it's on there. And if it's not on
Yeah.
there, shall I prepare an order granting that motion?
no, because it's the order to withdraw would have to be, we have a specific order in the division on
Yes, Your
withdrawal,
Honor.
so, but I'm pretty sure that that's been done previously.
Okay.
So let me have those 2 orders.
Yes, Your Honor.
Okay, all right, what else, Arthur?
Number 14.
Morning, Your Honor. Ernesto Medina on behalf of the plaintiff is requesting an additional 120 days to obtain service to the defendants.
Okay, all right. I mean, it's a, you know, it was filed in early 2016.
Right. But I've got some defendants already defaulted. I just need a few
Okay.
more to
Okay.
put a number.
All right. I'm going to grant it, but
Thank you, Your
it's
Honor.
not going to get
Yeah,
granted again.
no,
So
right. No, I'm
okay.
going to move on it.
Okay.
Thank you, Your Honor.
Okay. Great. Thank you.
Thank you,
On
sir.
number 6, there is no, zero, no trial set, no trial judgments.
Okay. All right.
Number 6, Roy. Let's revisit number 6 again, please.
I'm going to grant it. We checked. There's no trial date and no summary judgment motion set, so it's granted.
Number 8, Jimmy.
All right. All right. Which one? What number?
Number 8, Your Honor.
Number 8.
Plaintiff's motion for summary judgment. Defendant Jason Joel and his wife are defaulted. There's only one other defendant, Miami-Dade, who filed an answer.
Okay. Anybody else here today? Anybody opposed it?
No, Your Honor.
Because I was going to grant it unless somebody showed up today. So, jeez. What's your request as far as a date is concerned?
Next available.
All right, so it's going to be May 10th. All right, thanks.
Number 10,
All right, number 10.
City of
All
Miami
right.
versus Joe Bird.
Right, is you're representing the plaintiff?
The City of Miami, and
Okay.
there was a guardian ad litem who has since asked for dismissal. The owner was dead. He since demolished the property. Nobody lives on the property. It's a vacant piece of land, and we had a code enforcement lien, Your Honor, on that property of roughly $200,000.
Oh my God.
It's the per diem.
good day.
Oh, okay.
And additionally, we have a unsafe structure lien. But basically, once the owner died, everybody walked away from the property and just wore it down to the ground. So we went ahead and demolished the structure, and now
Right.
we're looking to recoup our cost associated with it.
Okay. You have no. I haven't seen any opposition to it. Any.
No, because he died, and what happened is the uncle of the man who died who owned the property
Right.
took all the money from all the tenants and did no
Oh.
repairs until it was.
Okay.
And then, bye, catch you later. I got my money. Didn't have to pay a dime. So the city cleans up
All
the.
right. Now, you're looking for a foreclosure sale date.
Yes.
Give me an approximate time.
It doesn't matter, Your Honor.
Okay. I'm going to set it for the next available. It's going to be May 10.
Okay. You know what, Your Honor? Since we're new to this, can I have a one later in May? I apologize.
Okay.
I just realized that I'm out.
Because
the
you are going to
country.
have to, the next, May 31st.
That would be fine.
Okay.
I just realized that I'm out of town and we don't normally do foreclosures in our office,
No,
so.
it's true. I mean, this is.
So
this
I
is
need to make sure that
unusual.
everything goes smoothly.
Okay. It's gonna be May 31.
Okay, thank you, Your Honor.
I mean, my thought is you should drop down by the clerk's office.
Okay.
Downstairs, they have a, foreclosure clerk who does nothing but,
Yes.
part of it, so.
And I haven't done this in 20 years. So
Okay. Well,
it's all
this is
computerized
unusual
now.
For the city,
Yeah.
for the city to be doing this. We need it.
Thank you very much.
All right, thank you.
Number 11,
Good morning, Your Honor.
Good morning.
So Hernandez for the plaintiff. This is plaintiff's motion for default against Carlos Abreu.
And you've checked, and as of today, there is nothing.
Correct, Your Honor. Nothing has been filed. There was notice sent on March 8th to all parties, and they're not here today either.
Done. It's granted. Do you have an order?
Yes, Your Honor.
Great, thanks. All right, what else, Arthur?
number 5,
Good morning, Your Honor.
Good morning.
Morning.
This meeting here on behalf of the plaintiff, Stacy Green, in this foreclosure matter where she's foreclosing her promissory note for $50,000.
Your Honor, the defendant his name is Mark Panunzio, and he has represented himself in this case. He asked me to cover this hearing for him today. My name is Laura Templer, and I'm appearing, my appearance is limited to the hearing today.
Okay. All right.
I don't know.
I haven't seen, has there been a response?
Yeah, now, I received
So-
an affidavit from the defendant.
Right, I got
Faxed
it.
to me on Monday. As an officer of the court, I typically cancel hearings on motions for summary judgment if I see there's a question of fact or law. In this case, I didn't see any, and that's why I'm here today. He raises two issues in this case. This loan of $50,000 by the plaintiff was to her ex-husband. So there was a divorce, and she gave a loan, the parents of the children, so she gave him a loan. So he raises in his affidavit that there's a question about the promissory note. Doesn't say when the payments are due. Promissory note's clear. I'll show it to Your Honor. It's a small, short-form promissory
No,
note.
I read the motion.
And then the mortgage is incorporated in it, and the mortgage also says if you default. So there's no legal question on that issue. The second issue he raises could create a factual question, though. He says the statute of limitations has ran. However, in my client's declaration in support of this motion for summary judgment, she succinctly addresses that in paragraph 21. I'll provide Your Honor a copy. And the defendant acknowledges in his opposing affidavit that he has not seen the movant's affidavit.
Is that the complaint that you handed?
No, this is the declaration by the plaintiff in support of her motion for summary judgment, where she explains that after the alimony he wanted more time, and more time went by, and then she filed within the 5-year statutory period for statute of limitations on a written document. And he states in his affidavit that he hasn't seen this, so I don't know why it is he didn't see it. It's a public record on the docket.
Let me see the
I have an
affidavit, please.
I have, my argument is twofold, really, in response to Mr. Levy's argument. First of all,
Okay, hold on. Let me just give me 1 second and let me read the affidavit.
which affidavit did you read?
The one that the defendant faxed to me on
I
Monday.
was getting ready to hand him that. I wasn't sure. Your Honor, my position would be that this, paragraph 21, well, first of all, the Amstone case clearly states that the affirmative defenses need to be refuted. I have a copy of those if you'd like for me to show them to you.
Of the cases?
Of the affirmative defenses that were filed. The Amstone case, the law is clear that in a motion for summary judgment, that burdens on the plaintiff, and the plaintiff has to refute the affirmative defenses. So, first and foremost, my position is the affirmative defenses have not been refuted by any evidence that was filed in this case. Secondly, paragraph 21, and I can show those to you, Your Honor, if you'd like. I'll hand them up. Secondly, the paragraph 21, these are statements that the plaintiff is making in terms of what she agreed to and when his last alimony payment was and what she agreed to. These are all factual questions. This paragraph actually underscores my argument that there are issues of fact such that summary judgment should not be granted. These are the affirmative defenses I'm handing up, Your Honor. So my argument would be that this case definitely has questions of fact, questions as to what any subsequent agreement was. She's saying she agreed to certain things in paragraph 21. The affirmative defenses haven't been waived, and which clearly state that the statute of limitations have run, which really go to this statement that she's making as to when she decided that she was going to let him start making payments. And the other affirmative defense is that the note is unclear as to when payments are to start. The note references interest, but there is no interest in the note. And so there's some internal inconsistencies within the document itself, as well as factual questions regarding the payments when they were supposed to be made. And that's raising our affirmative defenses. They really haven't been refuted.
All right, so your argument is the note should never be able to be enforced, and the $50,000 was $50,000 that was a gift.
And by the way, the other thing is she didn't lend him the $50,000. That's the term lender is incorrect, because this was purportedly part of a divorce agreement. So it wasn't as though she lent him $50,000. It was more a question of it was sort of an agreement after alimony or after child support, then he'll pay her $50,000. So there was never an exchange of money. She never gave him $50,000, lent him. So even that term is somewhat ambiguous in terms of she's not really a lender. But my argument is that these issues should be fleshed out at trial. My argument is that summary judgment is inappropriate when we've got various issues of fact floating around and affirmative defenses that haven't been refuted.
Last word.
The paragraph 21 succinctly disputes every affirmative defense factually. The defendant had more than 25 days, a month, to contest this. He has not contested. He has not said he didn't owe the money. He's only trying to get out of it by claiming the statute of limitations. But there's nothing of record factually to dispute what has been stated in paragraph 21. There's allegations in an affirmative defense, but this paragraph 21 factually sets forth the answer to all those affirmative defenses. And I know Your Honor is fully aware of what I mean with regard to Rule 1510.
All right. Here's what I'm going to do. And I'm making it harder on myself by doing this, but I'm going to respectfully deny the motion. I think we're going to end up having to resolve these issues at trial, which is why I say I'm making it harder on myself. But I think in an abundance of caution, I'm going to respectfully deny the motion. Okay.
Thank you, Your Honor, for your time.
All right, let me give you all back the
Thank you.
paperwork. Okay. All right.
Just have a blank order.
Yes, that's
Close
all
it
I
out
need.
now.
Yeah, I mean, go ahead, take
I
one
also
here,
have
fill it
a
out.
foreclosure order, but abundance of caution.
Well, yeah, save that for,
I'll save that for the trial.
for after the trial.
That's it, Judge. There's only one person missing that you want to see another judge, and
Okay.
he's just not here.
All right, well, you know,
So I see
I'll
number-
finish
number-
doing all of this, and then if
number
I'm still
4.
in chambers, have them come in and I'll, you know, because our hearing is at 10:30, so,
Very, very well, sir. Thank you.
Thank you for your time.
thank you.
Thank you.
Go ahead.
Always give me a copy. Yes. Let's bring it back on our conference.
That one. Okay. Thanks. Which one is it, Arthur, that we're waiting on?
Judge is number 4,
Number 4.
and he said
Ah.
he doesn't have it. Nobody else checked in, except him. He's
Okay.
actually the plaintiff in the
All right, because that's an interesting one. So, all right, if as soon as he comes back, let me know.
Absolutely, sir.
Okay. All right.
Thank
Thanks.
you. All right, please.
Yes.
Please proceed.
No responded, doesn't, so
Well,
wherever
Mr.
we.
Kimball, you can actually say that right now if you like,
Okay,
because nobody else is.
I'm gonna spread out,
Okay, very well.
because we're the next event, I'm assuming?
That is correct.
Okay,
Yes.
thank you.
Yes, it is.